Okay, good afternoon, everybody. Welcome to today's webinar, where we're going to attempt to answer all your employment law related queries. We have got a number of questions already in that we're going to pose to our panelists today. But if you've got any other burning questions as we go through, if you want to pop them in the question and answers function, then we will hopefully pick those up and answer them as we go along. We will keep your identity anonymous if you want us to do that. But if you want to leave your details and we're not able to answer your question during the session, we'll try and follow up with you. What I would say just at the start is that we're not going to be able to answer sort of lengthier scenarios with lots of facts in them. Probably not great to do that on a session like this. So we'll try and keep the questions more general. But if you do want to follow up on anything, then let us know and we can do that. Okay, so hopefully now people have joined. I, just by way of introduction, I'm Lynne Marr. I'm a partner in the employment team at Brodie's, and I'm joined by a number of my colleagues. But what we do regularly in employment law is to try and give holistic advice to all of you, and that sometimes means drawing in on other specialists in the firm. So I'm joined today by Karen Davidson, who's a partner in our tax team, by Elaine, who is one of my fellow partners in the employment team, but also specialises in immigration, and also Martin Sloan, who it probably gets fed up of me phoning him to ask him data protection questions. So with all that said, Karen will be delighted. I'm going to pose a question to her first, which is in relation to the taxation of termination payments. So Karen, we've had a question which is around the taxation of payments and settlement agreements. And the question is around what happens when you put in restrictive covenants or confidentiality provisions in a settlement agreement, because the questioner has heard that there is a risk now that even if the settlement sums are less than the 30k ex gratia amount that's tax-free, that there's a risk that the payments could be taxed.
Good question, and there have been a few cases on that recently. The point is that restrictive covenants and payments for restrictive covenants are actually taxed separately and outside of all of the provisions that deal with termination payments. And so there is a risk that you'll have a payment that's taxable even if the overall settlement is less than the £30,000 threshold. And it's important to remember, in some of the cases I've drawn this out, that restrictive covenants cover more than just anti-compete provisions or non-solicitation provisions, and they do cover things like confidentiality obligations that you have mentioned. I think the key points are, if all that's happening is there's a restatement of what's already in somebody's employment agreement, so they're not really being given any more onerous restrictive covenants, and it's just a restatement, it's unlikely that HMRC would look to allocate some of a settlement to that and make it taxable. But if there are genuine new restrictions being agreed to, then HMRC will potentially look at a settlement and decide to tax at least part of it in relation to a restrictive covenant. And the way to deal with that, I guess, is to think about it at the outset. What is being what covenants are being given? Should we allocate a sum to this particular restrictive covenant? Is it a new one? And it is sensible to allocate a reasonable amount to that, for fear of HMRC, I guess, allocating a larger proportion. HMRC aren't bound to stick to your allocation, but if it appears to be reasonable, there's less chance of them opening up the settlement and looking to make a part of that taxable.
Okay, and does the same apply to confidentiality, non-disparagement? Is that? Yeah,
that's exactly right. Yeah, so anything that is a restriction on activities that wasn't already agreed to in terms of their employment terms could potentially be taxable. Yeah.
Yeah. So keeping the fact in terms of the settlement agreement confidential or anything like that would be covered.
That's right. Yeah.
Okay. Yeah. So it's certainly something that we've come across a lot. So we've updated our template settlement agreement in Workbox so that anyone that's using those can see that. But it's certainly something that seems to be coming up a lot. On a related question, I've come across this a lot, and something that quite a number of clients have asked me is around injury to feelings, where what is being settled in a settlement agreement is a discrimination complaint, and they're trying to make it as tax efficient as possible. And an individual employee may be asking the employer to take some of the settlement sum, which is over £30,000, and assigning it to injury to feelings instead to make it tax-free. Is that okay? Is the question that we're asked.
It depends is the answer. So if it is injury to feelings that relates to discrimination that's not related to the termination, so it's a potential discrimination claim during the course of employment that isn't related to the termination, then there is potential to have that as a tax-free settlement of a discrimination claim. However, it's become pretty clear that HMRC will consider anything that's related to the termination. So if the termination itself is discriminatory, or if there's injury to feelings allocated as part of the termination payment, then HMRC will consider that to be taxable. So it's not possible to make it more tax efficient by simply saying this is injury. And although there is provision in the legislation to which talks about illness, injury, and disability, injury to feeling is not considered to be part of that.
Okay, so it's possible, but be careful and think
Correct.
about what injury it's designed. Okay, perfect.
Exactly.
Right, I will leave Karen alone for a few seconds, and I will pick a question, maybe for Elaine this time, I think. So we've got a question, Elaine, about the sponsorship management system and what you do when you're requesting certificates of sponsorship for candidates switching between categories, so from skilled worker visas and when the immigration skills charge applies. So the questioner has asked if you're selecting the skilled worker route, graduate and tier 4 student route, switching into skilled worker, you're not being charged the immigration skills charge up front, but sometimes you're being sent a payment link a few weeks later. What do you know why that happens?
So the first thing, just to explain for anyone who doesn't know, is that the immigration skills charge is a kind of employer tax on any migrant workers who you sponsor. And generally it costs £1,000 if you're a large employer for each year of the visa. So it can be quite expensive. For a 5-year visa, it can be £5,000. There's some exemptions that apply, and those are quite important exemptions because it could save you that £5,000. And one of the most common exemptions that we come across is where someone's switching from being a student into the skilled worker. So if you go direct from student route into skilled worker, the employer saves that £5,000 if you're a large employer. The person who is asking the question here is saying what option they select on the sponsor management system. So when you come to do that, you explain the person switching from student route into skilled worker route, and that exemption should automatically flow through the system. But I think they're saying in some cases they're then asked to pay it later. So either that's an error on the part of the Home Office, because they shouldn't be asking for that immigration skills charge to be paid if the person's going direct from student route into skilled worker. Or one thing which some clients have sort of dealt with in the past and which might be relevant is in this case, if somebody's moving from what's called the graduate route, which is a post-study work visa, into skilled worker, you do have to pay that £1,000 per year of the visa. So my only query back to the questioner would be to double check that it's not someone moving from graduate route, in which case that would explain why you were being asked to pay the money and sent a link later. But if it's genuinely student route into skilled worker, there should be that exemption. And I would query it with the Home Office and try to get your money back, because you shouldn't have to pay it in that case.
Okay, thanks, Lynne. We have had other immigration questions as well, so I'll ask you one more just now,
Okay,
which is around the civil penalties for illegal working. Quite a lot of people have read that that's increasing to 60k. Is that right? And what can be done to avoid these sorts of penalties?
Yep. So that's true. It's another bad news day for immigration, because the civil penalty regime has had a cap of £20,000 for each illegal worker for many years. That's now tripling. So it's quite a sort of steep increase, up to £60,000 for each person if there is a breach of the sort of illegal working regime. And that means that the employer's not properly carried out right to work checks, and then you discover that somebody doesn't have permission to work in the UK. So yes, that's a change that's coming. The slightly sort of good news angle on that is that if it's your first breach and you've never done it before, there's various discounts available. So it should be a maximum of 45,000 for the first breach. And you can also get certain discounts for fast payment. It's a bit like a parking sort of penalty or whatever. If you pay quickly, you get discounts, and in other circumstances, you can get discounts. And we've actually challenged quite a lot of civil penalties for clients before. So I would say if you get hit with one of these, do come and take advice, because it might save quite a lot of money if there's any issue with the civil penalty that's been issued. But yeah, in terms of employers, you can get hit with one of these even if it's an inadvertent breach. You didn't know the person was
I was going to ask that.
working.
What happens if you it's a complete mistake?
So if it's just a mistake, but you've not done the document checks properly, then yes, you can still get the civil penalty, unfortunately. And it is designed to make sure that employers have really robust systems in place to do right to work checks. And the other thing to note about right to work checks is, I guess, over the last year, the Home Office introduced new ways of doing those, which are quite good for people who've got workers in different locations across the UK. So you can now use third-party digital identity service providers to carry out some elements of the checks. For British and Irish passport holders, you still need to do bits yourself, but you can outsource bits of it, which has made it easier for some employers who've got people scattered all over the place. But auditing your own right to work processes is a really good idea, or getting third parties in to do that ahead of any kind of audit or whatever from the Home Office, because if you've got multiple civil penalties and they're each up to £60,000, you can see that the costs of that could rack up a lot. And we have seen businesses getting several ones at once when they come in to sort of check everything. If you discover 3 people at once, for example, that could be really expensive.
Okay, great. Thank you, Lynne. Right, Martin, I think there's some more questions coming in, but I've got one question for Martin, which is something that comes up for Elaine, and I will recognise this a lot, is where we get subject access requests in, or an employer gets them in for an employee, and they're asking for absolutely everything ever that's ever been held about them. Extremely onerous. Can an employer simply refuse to deal with the request if it feels completely disproportionate?
Thanks, Lynn. Yeah, so I mean, the answer is it depends. I mean, it really depends on what sort of volume of data you hold and how complex that is. So for some organizations, if someone's only been there for a couple of months, actually, an all data request might well be not unreasonable. But if you have someone who has, for example, been in an organization for 10, 15, 20 years, then you could have quite a large amount of data. And where these become really challenging for employers is that a lot of, particularly for those of us who work in jobs where you're primarily working in email, if you search a system for any email involving Lynne Marr, then you're going to turn up a whole load of stuff that actually probably isn't your personal data. So emails you've received, some emails you've sent, they're not really about you. You might have sent them, but they're not really to do with you. They're to do with your employer and your business and all that. And so doing a search of your IT systems may turn up tens, hundreds of thousands of items, which are all potentially personal data, but you don't actually know which of them are without looking at them all. So the Information Commissioner says, that you're expected to do reasonable and proportionate searches. So you then need to work out, well, what is reasonable and proportionate in those circumstances. And what you can do is you can say to the person making the request, you've been here a while, we've got a lot of stuff. Can you help us find the information that you're actually after? So in most cases, certainly the cases that we've dealt with you, Lynn, in the past, you generally know roughly what it's about. There'll be a particular instant or time period or something like that where really that's what they're after. They don't want to have all their internal emails with colleagues about going for lunch. It's more about some instant or a period of time or whatever it is. And sometimes people will actually engage with that and say, yeah, actually, well, it's this time period, or it's the communications with my line manager, or whatever it is, that then allow you to have a bit more focus. If they don't engage and they don't have to respond to that, they could just refuse to engage, then it's up to you as the organization to work out, well, what is reasonable and proportionate here? So you then think, okay, well, how do I find what I think this person is interested in? What searches can I do? So if you have 100 people in the organization called Martin, searching just for Martin is not going to help you find that information very easily. But you can need to apply a bit of logic, sort of sense here and say, okay, how did we refer to that person? So did we use their initials? Did we use their first name, second name? Can we look at the inboxes of particular people within the organization, or did we know that they communicated by Teams or WhatsApp? So applying a little bit of kind of logic to that will then help you work out where to look. So I suppose the short answer is, if you get an all information request, you can't just say no. you've got to actually work out what's come up, how difficult is this to respond to, and then try and work with that to see, well, how do we refine this, or can we refine it? And if you don't get engagement, then thinking, well, what can we then do to actually try and find that? And you know, there may be exemptions you have to apply as well, so you need to work through that as well. Some of the information may be exempt, particularly if it involves other people. We do have a bit of software that can help with this, so we use this quite a lot with clients, where you get a whole load of stuff that comes out of your IT searches. We've got so discovery software that uses AI to review and categorize stuff, and it makes a huge difference when you get that dump of 100,000 items. We can very quickly get that down to, well, actually, here are the 2,000 items we think are relevant, because we can exclude a whole load of stuff. We can find the false positives. So that's really worth looking at if you routinely find that you are dealing with DSARs and your initial search turns up a large amount of information.
Yeah. Well, particularly because you don't have very long to reply to if you've got a large volume of information, it's not very long you have to reply, is it?
Yeah, and if you're not an organisation that routinely gets large numbers of DSARs, you may not have the people internally who you can actually put onto this, because it is a time-consuming process if you have to start looking at things manually. So yeah, you've got your month to respond, and yes, you can pause the clock in certain circumstances, but that month goes past really quickly.
Yeah, I mean, one of the things that we get a lot, as you know, is DSARs being put in the context of grievances and disciplinary processes. Specifically, I don't know if you've got any top tips for dealing with that, or how you can handle them in that context.
Yeah, I think one of the things is to try and keep the two processes separate if you can. So you've got the whole employment law grievance process, which there will be particular ways you handle that. But DSARs are dealt with under data protection law, and while you want to understand what's going under both channels, you can need to have a bit of separation between the processes now you deal with them. So clearly, as the employed organisation, you're going to want to know what is being disclosed under each one, but you kind of have to look at each one on its own and not kind of conflate the process too much.
Yeah.
And that can be quite difficult when, particularly if the individual has, say, engaged lawyers who are dealing both with the DSAR and also with the claim, and they're just lumping everything together, but trying to maintain a bit of separation can be helpful in that. Other challenge, I mean, I suppose quite often we see this earlier in the process where people are fishing for information, and unfortunately there's not a huge amount you can do about that, unless there's a really clear abusive process. For the sort of grievance or tribunal process, it's really difficult to actually do much about that. You might have some challenges around things like working out what exemptions apply. Witness statements, it can be quite difficult. So thinking if you've got a witness statement, well, what have you said to people about the confidentiality of what they have said? Because it may be quite obvious if you disclose a statement as to who that person is, and therefore even if you redact it, it's going to be obvious that it was Lynne that said that. And so that can be challenging sometimes to work through and being clear, well, what did we say to people in this process? Did we give them any assurances about what we would do with that? So that's another one to think about. You need to know where everything is. So as I said before, a lot of this stuff happens on Teams and WhatsApp messages, and that's all potentially in scope. If line managers are communicating by WhatsApp, even if that's not an officially sanctioned tool, it's probably still
and that's often where we see the smoking gun, so to speak.
Indeed, because people write stuff in that, and they don't know that the default for Microsoft Teams is that everything is retained forever unless you change that. And we've seen in the last couple of years a lot of people get caught out because they hadn't realised that Teams was on stuff forever and a day.
Yeah.
So that can be a real challenge, actually trying to manage that. And after the event, people always start to think about data retention and deletion policies, and maybe it was better to do that by a phone call rather than do it in a Teams message.
Okay, thank you very much, Martin. Now I've had a couple of questions, but I think this sort of overlaps between Elaine and Can. So we are dealing quite a lot still with questions around hybrid working, and particularly people that want to work overseas. And we've got one question that's come in whilst we've just been speaking around somebody, an employee who wants to go and work in the Philippines for 3 months in every year in the local office there. So that raises questions around taxing. This particular employee, Karen, is saying that there'll be no tax implications in the UK. Is that correct? And then I'll come to Elaine after that, because they're also saying they don't need a visa either.
So I'll deal with the tax bit and then leave Elaine to have the joy of the visa answer. As you say, Lynne, we're kind of dealing with this sort of stuff all the time now, because post-pandemic people are kind of moving around a lot, and hybrid working offers up all sorts of new opportunities to people, and it does create some fairly complex situations from a tax perspective. On this particular question, I can answer the UK side. I can't answer the Philippines side, and I'll come on to that in a second. From a UK perspective, if you've got an employee who is going abroad to work only for a short period of time, that is unlikely to break their UK tax residence. And so that means that you are still required to be deducting PAYE income tax and doing employee national and employer national insurance contributions for those individuals, because they're still subject to UK tax. You're subject to tax on your on your worldwide income when you're a UK tax resident. So they are probably correct that there aren't any UK tax implications. But the difficulty is that there may be implications in the country where they're physically working. Most countries seek to tax people performing work in their country, whether their employer is based in that country or not. Different countries take different approaches as to how long you need to be working in that country before they will seek to tax that individual. And on top of that, there are a range of double tax treaties in place between the UK and all these different countries, which will set out the time period that you need to be working in a particular country before they can tax them, and what conditions might apply in order to get the benefit of that double tax treaty. And then on top of that, as if the income tax and PAYE position and the foreign equivalent isn't difficult enough, the national insurance and social security contribution position can often be even more complicated. So you might find as an employer that you end up with obligations in a foreign country that you weren't expecting to, if you don't take some of these requests seriously and get a bit of advice on it. So and the third point, so there's the income tax, there's the social security, and the third point is if you've got an employee who's quite senior and is going to be performing quite a senior function in this country, you also have to be a bit careful that you're not creating an permanent establishment for your own company in that jurisdiction as well. So I think the answer is fairly straightforward from a UK perspective, but it's the foreign jurisdiction that might cause the complexity, and you should have a serious think about that before you agree to it.
Okay, thank you. And Elaine, what about the visa situation?
Yeah, I mean, in terms of whether or not the Philippines would require them to have a visa, that's like not a UK immigration question, that's an overseas issue. And you would need to sort of take advice from local lawyers there before deciding that. Some jurisdictions, even if you're working for a really short period of time, you do need some kind of work permit. Other places might be more relaxed. But yeah, I guess in all of this, there's a cost in terms of having to go and get that advice in order to do things in a compliant way. And I would say I wouldn't leave it to the individual and just take their assurances, because lots of people say it's fine, I don't need a visa, I can do that. But yeah, you would need to take proper local immigration advice in order to be sure of it. And the other things you need to go and look into are local employment law implications. Is there anything from a local health and safety perspective, maybe data protection stuff if they're going to be, I guess, doing work from overseas, and other compliance things to look at. So overall, quite a lot of employers do decide it's actually just too expensive and complex unless there's a really good sort of reason to do it.
I think because people seem to have sort of forgotten the point that you've made, which is the local employment laws might be more beneficial than the UK ones. They might not be, of course, but they might be, and they would get the benefit of those. And you mentioned data protection, so I was going to bring Martin in at that point, because obviously if data is being moved between the UK and wherever they go to, there might be an issue there, I assume, as well, Martin.
It depends on how that person is employed. So if they are directly employed by a UK organisation, then actually there is no transfer. So whether there's a transfer outside the UK and therefore you engage all the restricted transfer rules depends on whether it's transferred to another legal entity. But if it's an employee who just so happens to be working remotely, then bizarre as it seems, as it sounds. Actually, data protection law says, well, that's fine. That's still there's no transfer because that person is still an employee of the UK company. On the other hand, if you were to set up a local subsidiary, or, you know, for tax purposes, they had a personal services company or whatever it may be in that local jurisdiction, then yes, at that point you would have a transfer, and you need to think, okay, right, so a transfer in this case to the Philippines. What do we need to do in terms of transfer risk assessment? How do we actually document that? How do we identify any issues that might arise from that?
Yeah, no, we don't have an insurance specialist on the call, but I know that some clients have had that as an issue as well, in terms of getting or checking that their employer's compulsory liability insurance covers them in other jurisdictions, because it very often doesn't under the relevant legislation. So yeah, a whole raft of issues beyond the horrible tax ones and the visa ones as well. Okay, thank you for that. I am going to answer a question myself, which I'm not going to let myself off scot-free, is around the changes to holiday pay. So some people have asked about that. I know earlier in the year, we were busy telling clients that we might be facing this rather horrible cliff edge at the end of this year, where there was a risk that with all the supremacy of EU law ending, there might be disappearing UK employment laws unless the government legislated to preserve them all. They've kind of flipped that on their head, and now everything's being preserved unless it's being revoked. And there's a very, very small amount of employment legislation being revoked that mainly relates to posted workers and the like. But we have had some questions around holiday pay, because people have said that there are changes being proposed, and this is a bit of a fraught area with case law all the time. So there are a few changes being proposed to the working time regulations. There have been questions about the calculation and whether the way that holiday pay has to be calculated is changing. And I suppose the short answer to that is that it's not really, that the legislation, which is coming into force on the 1st of January, essentially enshrines all the case law that we've seen. So we're still going to have different blocks of leave. So we're going to have the Euro leave, the 4 weeks of leave, and also our working time regulations, 1.6 weeks of additional leave is still going to exist. So holiday pay will have to be calculated taking into account additional pay elements like overtime, which is regularly paid, other pay elements that are connected to the discharge of your duties. They have to be included for calculating holiday pay for the 4 weeks Euro leave, but not the additional 1.6 weeks leave. So it's not created, or is not creating, the simplification that we had all hoped for. I think a lot of employers just calculate it the same way for both blocks of leave. But I guess the one thing to point out is that anyone who was waiting to see what was going to happen with all of this case law and whether the UK government would legislate. So if you haven't already thought about how you're paying holiday pay and what pay elements you do include, then now's the time to start planning for that, because that will become the law, if you like, within the UK from the 1st of January. So that's one point. The other things that are happening in holiday pay, people that are engaging any casual workers, part-year workers, there's 2 things to note on that, which are changes. So you will be allowed to use rolled up holiday pay again. That has been something that's been unlawful. I know a lot of employers do it anyway, but you are now going to be allowed to use rolled up holiday pay, so that if you've got people that work irregular hours, you can pay them a sort of supplement on top of their pay, rather than paying them holiday pay when they actually take leave. Now, that's not the same as saying that they're not entitled to take holiday. They do get their leave. It's how you calculate their pay, but that's possibly quite a helpful thing. And the other thing that's happening is to reverse the effects of the Harper Trust case, which you might all be familiar with, and that's how you calculate the accrual of holidays. So those sorts of workers now will cease to get what is proportionately more than permanent regular hours workers, and their holidays will accrue at 12.07% of their working time as well. So some changes to look out for there, and you'll need to plan for, because that is coming into force at the beginning of next year. Now I'm just going to have a quick look at the question function. I know we've got 1 minute left. I think some of them relate to some of the things that we've already answered. I don't know if maybe we've got time just quickly to leave a sort of mic drop moment for Martin, and AI and data protection. Is there any considerations that we need to be thinking about? And we can use it as a segue for a future seminar.
So I will try and give you, I suppose, so yeah, generative AI, lots of questions on that, not just on data protection, but just generally around liability and risk of using that. I mean, what I would say is, I suppose, a couple of things. Make sure you've got the right people internally who are inputting into this. So legal, IT, HR, data protection officers, whatever, understand what, so all generative AI is quite different. ChatGPT is very different to a lot of the other systems that's there, but they all work differently. Some of them will retain data. Sometimes what you share is shared with other organizations, and that's why we get worried from a data protection perspective about people putting stuff in ChatGPT. And in fact, OpenAI says don't do it. But if you pay for the enterprise version, then you can do that, and they will provide you with a data processing addendum. So really important just to understand what you're using, what your use case is, and is there a risk there? Because if there's no personal data, it's lower risk in that side. And all of that kind of, we're working with clients to write playbooks for this so they can have an approach to risk. They can have an assessment process that uses a DPI, data protection impact assessment, for assessing the new use cases in the technology. And then all of that, having a good worker policy that tells your staff what it is they can and can't do, and what use cases are okay, and what to do if they want to use a new one. And there is on Workbox a template there that's a good starting point. You need to adapt it for your organization because everyone's different and we're all using it different ways, but it's a good starting point on your journey.
Okay, thanks very much, Martin. I'm afraid we're out of time, so all it really remains for me to do is to thank my panelists and also for all your questions. Okay, thanks very much for joining and enjoy the rest of your day.
Thank you.